It's not very often that the European Court of Human Rights decides that the Netherlands acted in conflict with the European Convention on Human Rights, but it does happen. The central question in this case was whether there was a breach of Article 6, and more specifically, the right of the suspect to be present when his case was heard at trial. In general, we know that the right to take part in a trial, according to the European Convention on Human Rights, is not absolute. It has to be weighed against the general interest of bringing a case to close within a reasonable time. The facts of this case would actually not be unfitting as a script for a crime series or movie. They were as follows. A considerable amount of hashish drugs had been transported from one hiding place to another. It was about 3 tons. And later it appeared that some of the drugs went missing. They were taken by somebody, and consequently a body was found dumped at a building site. And the hands of this body were tied behind his back. He had 2 broken ribs and holes in his knees, consistent with the deliberate infliction of injury by means of an electric drill. So it appeared that the victim had been tortured, with the aim of extracting information on the whereabouts of the drugs. The applicant, Mr. Hokkeling, he was arrested some months later on suspicion of being criminally involved in these events, so causing the bodily harm, causing the death of the victim, abduction of the victim, and importing, transporting, or at least possessing the 3 tons of hashish. The proceedings before the Dutch criminal court were as follows. During the proceedings in first instance, it was decided by the Alkmaar Regional Court that it couldn't be established that the abduction had resulted in the death of the victim. However, Hokkeling was, in fact, convicted of the remaining charges, and he was sentenced to 4 years and 6 months imprisonment. Then, during the appeal phase, the appeal hearing opened on the 31st of October before the Amsterdam Court of Appeal. And after opening the case, several adjournments happened, for different reasons. And in the meantime, the applicant was released. On the 18th of May, the applicant attended the hearing, but this hearing was again adjourned because further witnesses needed to be heard by the investigating judge, at the request of the defense. And then the trial was again adjourned until the end of October 2009. So why are all these dates so important? Well, that is because meanwhile the applicant was arrested in Norway on suspicion of transporting or possessing a considerable amount of narcotic substances. So he had allegedly committed a new offense meanwhile. His defense lawyer informed the Dutch Court of Appeal of this development, and the hearing was resumed at the end of October. The defense lawyer was then present, and he stated that his client was in prison in Norway, and he asked for his transfer to the Netherlands. In March 2010, the applicant received a summons at his detention address in Norway to appear at the hearing of the Court of Appeal. And again, the defense lawyer requested for his client to be brought to the Netherlands. But this didn't happen, and on the hearing of the 1st of June, the defense lawyer asked for the hearing to be adjourned until his client was transferred to the Netherlands, but the Court of Appeal declined to adjourn the case. The Court of Appeal used quite extensive reasoning for this decision, but in a nutshell, the reasons were twofold. First of all, the possibilities for transfer of the applicant had been considered by the court. Actions had been taken by the Advocate General, but neither extradition nor temporary transfer within the meaning of mutual assistance in criminal matters turned out to be possible. Second, the defense lawyer had been explicitly authorized to defend the applicant at the appeal hearing. And we should note there that Dutch law enables defense lawyers to fully represent clients in absentia. According to the Court of Appeal, the interest of bringing the case to a close within a reasonable time had to prevail over the right of Hokkeling to be present in person. What is important is that the Court of Appeal consequently convicted the applicant for causing grievous bodily harm resulting in death, for abduction and transporting and possessing an unspecified amount of hashish, and sentenced him to 8 years imprisonment. So this was almost double the punishment he received in first instance. The case then went to the Supreme Court, and the Supreme Court dismissed the applicant's appeal on points of law on summary reasoning. The applicant brought his case to Strasbourg. And the proceedings before the European Court of Human Rights centered around the complaint that, in short, the applicant alleged a violation of Article 6, paragraph 1, 3c, the right to a fair trial and the right to defend himself in person or through his lawyer, on the ground that he had not been offered an opportunity to attend the hearing of the appeal in his criminal case in person. The court's assessment of the case was as follows. As always, the court started with some general observations, stating that Article 6 does not compel states to set up courts of appeal or cassation. But, and this is very important, when such courts are instituted, states should ensure that the rights of Article 6 are guaranteed. The right to take part in a hearing is not expressly mentioned in Article 6, paragraph 1, but it's part of the right to a fair trial, and it's difficult to see how defense rights mentioned in Article 6 can be exercised without being present. Proceedings in absentia, without the accused being present, are not in themselves incompatible with Article 6. Nevertheless, and this is a quote of the court, a denial of justice nevertheless undoubtedly occurs when a person convicted in absentia is unable subsequently to obtain from a court which has heard him a fresh determination of the merits of the charge, in respect of both law and fact, where it has not been established that he has waived his right to appear and to defend himself, or that he intended to escape trial. The general rule that the court states here is even more compelling when there is a possibility that the suspect is handed a more severe sanction in appeal, which happened in the case of Hokkeling. Turning to the present case, the court decided that it's clear that the applicant intended to attend the hearing of the Court of Appeal. The refusal of the Court of Appeal to consider measures that would have enabled the applicant to be present is even more difficult to understand, given the fact that the Court of Appeal increased the sentence from 4 years and 6 months to 8 years, and thus the court decides that there has been a violation of Article 6, paragraph 1 and 3 of the European Convention. And the most important quote of the judgment reads as follows: "The court agrees with the government that the applicant's arrest in Norway was a direct consequence of his own behavior. It also recognizes as legitimate the interest of the victim's surviving kin and of society as a whole in seeing the criminal proceedings against the applicant brought to a timely conclusion. Even so, having regard to the prominent place which the right to a fair trial holds in a democratic society within the meaning of the Convention, the court cannot find that either the applicant's presence at hearings during the first instance proceedings and the initial stages of the appeal proceedings or the active conduct of the defense by counsel can compensate for the absence of the accused in person." So the court is quite clear that they think that under the given circumstances, Hokkeling should have been able to be present in person during the trial proceedings in appeal. What's very interesting in this case is the dissenting opinion of Judge Meyer. And he took this opportunity to strongly disagree with the majority of the judges in the case. So it was a 6 votes to 1 judgment. And the first sentence of his dissenting opinion is rather illustrative of this fact. He says, "I do not agree with the majority. In my opinion, the majority didn't sufficiently take into account the very specific circumstances of the present case." So why is that? He agrees in his dissenting opinion that the reasoning of the judgment is in line with the general case law, and it appears convincing, but as he says, the outcome doesn't feel right. He states that this feeling has to do with the severe violent character of the case and the facts of the case. The applicant claimed to be innocent, and in appeal, when the case was adjourned for the last time, the applicant was told to be present at the 3 new trial dates at the end of October. And for Judge Meyer, a crucial point was that the applicant was subsequently arrested on the 4th of October for smuggling large amounts of amphetamines and cannabis. Thus, the arrest was not connected to old suspicions in old cases allegedly committed before the facts tried before the Court of Appeal, but it was connected to new suspicions. The applicant, having been notified that he was expected to appear in person before the Court of Appeal in Amsterdam, traveled to Norway 3 weeks before that date to oversee the transport of drugs in person. And in the words of Meyer, that is a situation in which, in my opinion, he himself is totally responsible for not being able to appear on the 27th of October. In my opinion, Judge Meyer says, the line of reasoning in the present judgment should accordingly have been, firstly, that the applicant himself was not largely but fully responsible for bringing about a situation that prevented him from appearing before the Amsterdam Court of Appeal, and secondly, that the Court of Appeal nevertheless tried to see if there were still legal possibilities, based on international treaties, of having him brought to the Netherlands, and for that reason again adjourned the case. Thirdly, that the Court of Appeal took into consideration the fact that at least the applicant had been allowed contact with his Dutch lawyer in Norway. To put it differently, and these are still the words of Judge Meyer, the Amsterdam Court of Appeal did everything it could to guarantee the Article 6 rights of the accused as far as possible. And then there's a sentence in the dissenting opinion which is most interesting, I think. Judge Meyer says, "I'm fully aware that crooks have human rights too. Even crooks who are suspected of having abducted and tortured a victim and left him for dead on a building site. But that doesn't mean that this applicant has an absolute right to take control of the way the proceedings against him should be handled and of the time when hearings should take place. And although this may sound slightly exaggerated, I repeat that the judgment doesn't feel right to me." This is still Judge Meyer. "Worse still, I will have great difficulty explaining to others that in the particularly gruesome circumstances of the case, Article 6 has been violated." Looking at the dissenting opinion of Judge Meyer, I do understand his way of thinking, but I do think that his line of reasoning is a risky one. In his dissenting opinion, he's mainly focusing on the severity of the case and of the alleged facts, and this may lead the more shallow listener or reader to believe that the rights of Article 6 can be put aside just because the applicant was suspected, and I think that's very important. He was suspected, not yet convicted, at least in appeal, of very serious crimes. I think I do not have to explain that this can be a dangerous way of thinking. To be honest, I believe quite the opposite should be true, especially when the facts are very serious, and as a consequence there's a lot of stake for the defendant. Fair trials should be taken into account as much as possible. And yes, this might sometimes result in judgments of the European Court which are hard to explain to the general public, and it may even not feel right when looking at what the applicant has eventually been convicted of, but that's a small price to pay for giving the rights of Article 6 the practical effect that they deserve to have. The judgment in the Hokkeling's case clearly demonstrates how much the European Court values the right of the suspect to be present at its hearing, first instance or appeal. The fact that it's the applicant's own fault that he cannot be present is, in the given circumstances, clearly not decisive for the court. So in conclusion, it is clear that there are limits to whether and how courts can give way to efficiency when deciding on proceeding with the case in the absence of the suspect. Proceedings in absence of the suspect are, according to the majority judgment, not per se in breach of Article 6, but the courts have an obligation to take certain aspects into account. Has the suspect expressed the will to be present? Is the suspect at large or in detention? And what is at stake for the suspect? Is there, for example, a possibility of a more severe punishment? When a suspect is detained, as was the case in Hokkeling's case, it is less easy for the courts, apparently, to decide to proceed without the presence of the suspect. And without a doubt, this judgment will be used on a regular basis by defense lawyers asking for an adjournment of the case.